education training is very important. First, I think to enhance the awareness of the role of mediation in the dispute settlement. We should put mediation as a formal subject matter to the curriculum, parallel with other means of dispute settlement, arbitration, adjudication, and others. But now it's not yet, because the people consider mediation is quite informal. In fact, it's more important. So that's the first thing. Secondly, is two ways. In Chinese, we say walk with two legs. It means one is the formal academic training in the curriculum. Secondly, is ongoing training, continuing training, particularly for those high reputation people and solid knowledge of subject matters, and most of them recently retired people. I learned in France, for instance, in the trade association, dispute settlement, mediation, they use those former CEOs. Or in Pakistan, they use ombudsman. I think the similar thing in China, in the village community, they use the elder, experienced person because they have a high reputation, honest, fair, independent. So those training very important because we should use the limited resources to train training of trainers, and then they will bring their village and to have more mediators, particularly in the professional association for the subject matter. They are very solid, like a family dispute, or consumer disputes, or commercial or banking disputes. We need to have former CEOs from banks. And then if they have solid knowledge of the methodology of mediation, and they can facilitate the mediation faster and more efficient. So I think in this area we need more international cooperation. So this across stretch the continent, ocean. Yeah, we will have more efficient cooperation. Thank you very much.
This may be a good juncture for me to introduce Julian Holloway. Julian is a partner with Berwin, Leighton, Peisner, LLP, a British law firm. Julian has engaged in all forms of dispute resolution for over 20 years. He has been a mediator for 15 years. He can't say that he has mediated 4,000 cases, but he has helped parties in over 100 cases. He is also an arbitrator and an adjudicator within the UK construction scheme for resolution of construction disputes. Sadly, Julian doesn't speak Chinese, but he does speak French and German, and therefore very much appreciates how difficult it is for someone to conduct negotiations in a foreign language. It makes dispute resolution, which is difficult enough, even more complicated, of course. Thank you.
I think in relation to the selection of mediators, and since we are talking about the cultural differences of mediation, certainly in the context of cross-border disputes, it's often helpful to have someone who actually understands both the language of the two different parties and who understands the cultural differences. I recently had to mediate a dispute between a French and an English company. There are some who say that the differences between England and France are so great that I'd never have any chance of dealing with that. But one of the problems that arose halfway through that was that one of the more important documents had been effectively mistranslated into English. And it was one of the areas where I, as a mediator, was able to bring something to the table, because between us we could work out that actually it meant something slightly different. I also had to spend a lot more time in gaining the confidence of the French party, who were very unfamiliar with the process. And that's something I think that in relation to cross-border disputes is an important aspect.
Thank you very much, Julian. I have a comment in relation to Madam Zhang's good comments earlier. and that is in the United States, is there a continuing education program for the professional mediators?
Let me respond to that. Again, the lack of regulation and licensing for most jurisdictions in the United States creates a situation to where there's no requirement that for such activity. There are many opportunities, and frankly, many of the most successful mediators do join with different organizations with similar successful mediators for them to get together and to encourage and support and to stimulate each other with workshops and discussions of difficult issues. Some panels, if you join certain panels, they will create those opportunities and sometimes those requirements as well. So at this point I would say it is largely voluntary for such activity, but that the people who are very successful do participate in national conferences or regional conferences or in some kind of panel educational program.
I just want to add something very briefly. It also depends on whether you belong to certain membership organizations. So, for example, the Association for Conflict Resolution, which has about 7,000 members in the United States, there are certain levels of membership. And there is a general membership and a practitioner membership and an advanced practitioner membership. And in order to be at those different levels, you're required to have continuing education. So the advanced practitioner membership has hours required, consultation with other advanced people required, interning required. But again, the membership in that organization is voluntary, so it's not a requirement to be a mediator that you belong to that organization. If you do belong to that organization, you must do continuing education if you want to be at certain levels.